you don't want to wait until the person is having concerns with cognition to be able to put the healthcare power of attorney in place, to be able to put the durable power of attorney in place. No attorney is going to do that. Legally, they can't do that because the person clearly is having cognitive issues. You want to do that even if they have dementia. In the early stages, they can still make decisions for themselves. They don't have to have a guardian in the early stages, but you want to be sure that their healthcare power of attorney is in place. So if they ever lost capacity or was incapacitated, then that's when the healthcare power of attorney kicks in. But if there were no documentations in place, no documents in place early on, that's when the probate court and the family court comes in, and that's when the guardian is appointed, the guardian ad litem is appointed, and all these people are appointed to serve in the best interest of that vulnerable adult. And guess who has to pay for those people? The vulnerable adult has to pay for those people. Wendy has to pay out of her pocket for her court-appointed guardian. If she had a guardian ad litem, she has to pay for that. And she also has to pay for her attorney, the attorney that the judge assigns. And so those three people, they have to be compensated, and they're compensated with the vulnerable adult's money. That's why I think one of the reasons why the system is broken is because the person didn't even ask to be in that situation, but they got to pay out all that money, which is why if you are in line to provide care for someone who is going to be aging in place, like your parents or your grandparents or your loved one, you want to work with them right now on getting that health care power of attorney in place and the durable power of attorney in place. You also want to be sure that you're on their financial records, because sometimes the banks won't take the durable power of attorney. They want their paperwork in place as well. And also, too, you want to have this stuff in place for yourself, even if you're nowhere near 65, even if you're not having any cognitive issues. You want to make sure you have your healthcare power of attorney in place, because you could have an accident, an injury, or an illness today, and you won't be able to make decisions. So what happens when what happens when, I don't want to say you're incapacitated, because that may not be the case. If you are in a situation where you are unable to cognitively and clearly make a decision for yourself, does not necessarily mean that you're incapacitated, because that's more longer term. The law is, in South Carolina, we have the Healthcare Consent Act. In other states, it's a form of that. It may be a different name, but it's a form of that. That Adult Healthcare Consent Act it has a list of people who they're going to refer to make a decision on your behalf. The first person is the spouse. Then it goes to the children. Then it goes to the parents. Then it goes to the siblings. And in some cases, I've had the first cousin to make the decision.